Welcome to Exoneration Nation podcast. I'm your host, Christopher Scott. Today on the podcast, we have Judge Brandon Birmingham, and we're here to talk to him about Dallas deselection. And the reason I started this podcast is because I wanted to give people information that some people don't get or don't receive well. I was wrongfully convicted in 1987 for capital murder. I did 13 years in prison for that crime. I'm the first non-DNA in Dallas County history. So just imagine leaving your home one day, girlfriend and kids at home. Next thing you know, you being charged with capital murder, not knowing what actually happened or whatever. And I was investigated and interrogated for numerous hours. Finally, the cops said they was tired of speaking to me and I was being charged with capital murder. When they first came to me, it was about drugs, about me being a drug seller. And where did I get my drugs from? After 3-4 hours of interrogation, they said, well, we threw bullshitting with you, and now you're going to jail for capital murder. At that particular time, I didn't even know what capital murder meant. 5 minutes prior as me leaving, the officer walks up to me and said, Mr. Scott, I do not believe you actually committed this crime. And I told him, no, I did not commit this crime. And he told me the reason he felt like I didn't commit the crime. He said, for one, the lady just saw you 5 minutes prior to us putting you in a lineup, and she couldn't pick you out. And then we asked her, why couldn't she pick you out? And she said she was scared. And the officer said, scared of what? Scared of Mr. Scott? And the lady said, yes, I'm scared of Mr. Scott. And the officer asked her, how could you be scared of Mr. Scott? And Mr. Scott is locked up in a room with 4 officers, and you locked up in a room with at least 12 officers around you. Now, how could you be scared of Mr. Scott? So he came back, he said, those are the reasons that I felt like you didn't commit this crime. He said, for one, you well dressed, you well spoken, you well groomed. We found an uncashed paycheck stub in your pocket. And then he said, number 2 is, this does not fit the crime of a person of your caliber. This fit the crime of a dope fiend. This is what the cop officer told me. And he told me to subpoena him to court. He would testify in my behalf saying it's not one shred of evidence would link me to this crime. Also, we had a lieutenant come to the police station and to my trial with the 2 perpetrators that actually committed this crime. And the judge and the prosecutor told the cop, the lieutenant, to leave their courtroom. They didn't want to hear it because it was hearsay. Now I'm thinking like, this is a cop that was sworn in to serve and protect us, but you telling him that it's hearsay. Story being short, that I end up having a 3-hour trial. Deliberation lasted about 10 minutes, and I was found guilty of capital murder with no DNA in it. And I would ask myself sometimes, how could I get exonerated or get my case overturned without no DNA? So this is the reason I started this podcast, to bring people on my podcast that can explain how things like this happen and where things like this go wrong. So Judge Brandon Birmingham, thanks for being on the show. Glad you can be here. Explain to us what Dallas deselection is.
Well, first of all, it's very good to see you again, my good friend. And I think it's you're part of a group that I've learned a great deal from. You know, the exonerees in Dallas County is a tight-knit group, you all are. And right. I think that's wonderful. You help each other out. Right. The new ones come in, you all take them under your wing and help them come out. And man, you're still doing the work with House of Renewed Hope. So it's great to be here. And thank you for including me on this. Dallas deselection is a study that I'm doing about jury selection. Right. Let's just start with the title. Dallas deselection. Dallas because it's all focused on juries that were selected in my court. I've been the judge now of the 292nd, a felony court, just like the one that you were convicted in, for 7 years now almost. And when we do jury selection in my court, I always take notes about who was selected and who was struck and who couldn't serve because they couldn't follow the law.
Right.
And I'm taking those notes with all of the jurors who were selected. We've been able to gather about 50 trials, about 3,700 jurors. And really what I'm trying to figure out is who is being struck. Is there a certain group, a class of people, a race of people, age group of people that's being struck more by one side than the other? Right. And this is what's unique about the study is it's not just looking at the age and the race and the gender and whether they serve or not, but why. Right. It's jury selection is the second half of the name comes from deselection. Jury selection is not a draft like the NBA and the NFL, right? It is a process of deselection. So for those people that are listening to the show can understand just real quickly, the way the process works is that each side gets 10 strikes in a felony case. The defense gets 10 and the state gets 10. 12 jurors are needed to fulfill the requirement of a jury, right? So that's 32 people that you got to have. Right. Now, some people are not able to serve because, let's say, a medical reason, okay? They have a medical reason. Some people can't serve because they've been victimized of a crime. Right. Some people say that because of their moral or religious belief, they can't follow the law. Some people say they just disagree with the law because they think it's silly and they're not going to follow it. Some people have a bias against the state. Some people will look at the defendant and say, I have a bias against the charge. Anybody I hear charged with capital murder, for example, I already think they're guilty, so I can't follow that rule. And so what I've done is collected those types of cause questions and with the age, race, and gender to see, and also the location of where they are in Dallas. Right. And let's just see who's been able to serve and who hasn't. So it's a process of deselection. So the first 12 people after the state have used their strikes, the defense have used their strikes, and the people who the judge has determined can't follow the law, those first 12 in a row are the 12 jurors. So it's a really important study, I think, because really of two main reasons. First of all, just practically speaking, all of the facts that you just talked about that led to your conviction would be received by a jury. So who is actually on the jury? Like what type of people are there? Now, what I know just from my service as both a lawyer before and then now as a judge is that there's really only 1 in 4 people actually show up for jury service. That's it. Wow. 1 in 4. 3 out of 4 people don't even bother. So it's not accurate to say that you get a cross-section of the community when the community doesn't show up. Right. Then the second reason why that's important is because the whole purpose of having a jury is that a jury of the people that come from this area, wherever the area is, listen to the evidence and they make a decision. Not only is the evidence sufficient to prove to them that the guy did the crime, but then in Texas, as you know, we also jurors assess punishment. And so they have a stamp. In other words, they set the mark for what's the type and quality of evidence first for a conviction, and then second, in a given crime, what's the punishment range and what should it be? Right. If only 1 in 4 people are showing up, that's bad. Right. And then even within that group of 1 in 4, where do these jurors come from? Do they come mostly from the north? Do they come mostly from the south of Dallas County? Right. From the west, from the east? Are there zip codes that are more likely to be struck than not? From both sides, prosecution and defense. Right. And so that's what we're trying to do with this data. So it's Dallas deselection. And you know, obviously it's Dallas not just because of the jurisdiction. Right. But you know that we have a very sordid history in Dallas with jury selection. For sure. I mean, Miller L., there was a very famous Supreme Court case from the United States Supreme Court where it came out that there was a memo that went out to the felony prosecutors. Don't let, and I think the quote is, blacks and Jews and women serve on juries. Wow. And that was the instruction in the memo to the prosecutor.
It's great.
And so the history of Dallas is rich in exonerations. Right. It's rich, unfortunately, in the way that deselection was used to keep minorities off of jurors and women too. And so we'll see what happens. That's the study that we're in the middle of. Where we are is, when I say in the middle of, we've collected all the data and we're just going through right now and analyzing it.
Interesting, because when I went to trial and I was picking my jury selection, an African-American woman stood up and said, I can't be a part of his jury panel because we used to date. but I had never saw this lady.
She's talking about you?
Yeah. And I had never saw this lady a day in my life. Do you get those kind of answers all the time? Is that like normal for somebody to say something like that?
I mean, not necessarily like that, but the idea that they'll say whatever they can to get out. Yeah, right. Unfortunately, there's a lot of people that do that. Now, I understand that it's a big ask, to tell somebody you got to serve for a week, but yeah, that happens. People try to get out of it.
So is it more African American minorities that bags out, or is just real diverse of people that bags out of being on the jury panel?
I think most people just back out. Now, look, I can tell you I don't have an intuitive sense like one group does or not. I will say that I can tell you here when the study's done if a lot of people are giving those types of answers and if those people belong to one group or another.
Right.
I'm interested in seeing, as I said, the age of people, the race of people, the gender, but really also the location.
Right.
Dallas has some, 50 or 60 zip codes, right?
Right. Yeah.
I can't remember exactly.
Yeah.
But as you know, somebody who's lived here your whole life, and I have too, there's the idea that, I-30 runs east and west. What happens north of I-30 is different than what happens south of I-30.
For sure.
Is the perception that people have of the law and the criminal justice system north of I-30 different than the perception of those south of I-30? I suspect that it probably is.
Oh, for sure. No doubt.
And if so, is that reflected in the jurors that are actually serving?
Right.
In other words, you could say, and the hypothesis could be, is that the prosecutors are going to strike more people in the South.
Right.
And the defense attorney is going to strike more people up north. Right?
Yeah, sure.
And so we'll see if that pans out. Mm-hmm. And is there a group that's overrepresented from one side or the other? And so that's what all this data hopefully we'll be able to show.
So we did a study in California where California minority jurors were struck at a rate of 72% versus, 1% of rate of whites. Do you see that happening as the same as in Texas, or you think Texas is a little better in the jury selection of being African minorities being stricken?
I bet you, back in 1960s, 1970s,
Right.
It was probably like that. When that was it's called the Sparling Memo. I mean, that memo went out, and so I'm sure it was pretty close to that. So my data goes back to 2015 when I took over. I don't think it's going to be 75 to 1%. I don't think it's going to be like that.
Right.
But I do want to know if there's disparities, and if so, I want to know what those disparities are. And I'm also almost more interested in those people who say they can't follow the law.
Right.
Who are they, and why? Where do they come from? Those that say that, and that's going to be interesting to say too. But I will say that I think that we have gotten better in Dallas between 2015 and 2020 than we did back in the 80s, 70s, 90s. When your case happened, I think things have increased because of cases like Mr. Miller-Ells, Batson versus Kentucky, and I think also the advent of the accessibility of trials. Now what happens in Dallas, people all over the country hear about. Whereas before it wasn't like that. But now everybody hears about it. Trials are going on. People have greater access to information.
Right. So what recommendation would you have for other counties with abnormally high amount of defendants claiming wrongful convictions?
Well, I think first of all, you've got to have a DA who is separated from politics, who has an allegiance to truth-seeking as opposed to final convictions. A lot of it's not like when the very first time you went and you said, hey, something was wrong with my case. The DA was like, okay, Chris, let's go look at everything. You had to jump all kinds of hurdles. They all do.
Yeah, for sure.
And I mean, there should be some finality of convictions, but you should also have a DA who isn't going to unnecessarily stand in front of it. I think you got to have an open-minded judiciary to allow, within the confines of the rules, of course, people to re-examine and accept the idea that just because there was a conviction on a certain day that the case isn't over. It's never over. You should never stop looking for the truth in a case. And you know, you've been involved now with these exonerations for a long time. And you know that some people come and man, there's something to it.
Right.
Some people come and it looks like there's something to it.
Right.
But then he's like, no, man, you really did do that. You know, you've had those.
Yeah, I had those before, yeah.
But okay, so what's wrong with re-examining that?
Right, exactly.
And now you know.
Now you see, that's my whole point of view. If you seek for justice and you seek for the truth, eventually you'll get it.
Yeah.
But at the same time, when that person that we was trying to help get exonerated, we end up finding out that he actually committed that crime.
Right.
What do we tell the people? Like, do we tell the people world that this is something we got to get a hold on to? Because there's a lot of people claiming that they're innocent, that they're not innocent.
Well, you know, you tell me. This is interesting. When we were at the exoneration day on the steps of the courthouse, delicious barbecue, by the way. Who made that?
Pinchback did.
Pinchback, yeah, Johnny Pinchback. You told me, you said, you know, even in y'all's group, you don't like people that come at you with a fake exoneration story because it makes everybody else look bad.
Exactly.
You know, and you vet them and you do your own investigation and, you know, that kind of thing. And so tell me why do you do that? Why is that important to you?
Like I said, it's always about seeking the truth. And I don't want anybody to throw shade or a shadow over men and women that was actually wrongfully convicted.
Yeah.
It makes that situation look bad.
Right.
Because we fight for justice and we seek for the truth, but once we get it, what do we do with it? Do we share it with the public, or do we just take it up on ourselves and be like, it happened to me, it can happen to other people, but the people that seeking wrongful conviction and you know you're guilty, don't put the state through this much trouble and make them lose this much money.
Right.
Simple fact, you're trying to get over on the system.
That's right.
You know what I mean? The system, you just got to look at it. The system always going to prevail one way or the other. Is going to prevail. And, you know, a lot of times it has us looking like, you know, the bad people because, you know, some people still feel like some of us actually committed our crimes and we just got away with it.
Really?
Yes, a lot of them like that.
Even yours?
Yeah. Some people feel that way. I'm going to ask you another question. How hard will it be to get jury selection reform on a national level? What states may follow suit with the new software?
I think on a national level, man, that's going to take some rulings by the Supreme Court.
Right.
You know, every state, all the states are going to have different wrinkles. In Arizona, they're talking about getting rid of lawyer-led jury selection at all.
Right.
And you know, it has some appeal, but I, you know, I'm not sure that I'm for all of that. But I think there was the very famous case that came out maybe 2 summers ago, Flowers versus Mississippi, where you know, again, this was the prosecutors were caught engaging in conduct that was obvious that they were excluding minorities for jury selection on purpose, intentionally, and I think that public pressure can have an impact when were Batson challenges sustained. In other words, at the trial court level, one side says the other side engaged in rape. When were they sustained? How often and where? Right. Because I would imagine that what you'll find, and this is again my hypothesis, just based on my guess, I guess, is that in larger urban areas, you would find that number to be much lower than in rural areas. I bet. I don't know whether that's true or not, but I bet that you might. I think that you know how we talked about there's maybe 2 different views of the criminal justice system, north and south in Dallas. I bet you have 2 different views in an urban area versus a non-urban area in Texas and in other cities and states across this country. Oh, for sure.
Why do you think Dallas County leads the nation in exonerations?
Well, you had, I think it's pretty simple, really. 2 things happened. Number 1, the medical examiner for the Southwestern Institute of Forensic Science. Right. In the very early 80s. DNA was just over the horizon, you know. Right. And as I understand the story, she said, we're going to start saving all this stuff because someday you'll be able to detect what DNA is and whether it is, you know, and she recognized the value in the context of a criminal case. So she stored it all. Right. Other jurisdictions, most of them, were not storing them all. I mean, they were destroying them because there wasn't DNA. So, I mean, what's the point?
What's the point of having?
Dude got convicted. So well, we don't need to save it. Right? But she saved him. And because of that, guys like, all of the exonerations here, and except for you, had the opportunity to test the DNA. So they were given the opportunity. The second thing is you had a DA who was willing to test that stuff, who was, not going to stand in front of the testing and the truth-seeking function that the DA should have. Mm-hmm. And so they allowed it. Craig Watkins, the very first thing he did, comes in with the conviction integrity unit. He got laughed out of court. He got laughed at around the state by other DA's offices. I know, because I was there. It was one of the very first, I was a prosecutor under him. And one of the very first conferences that we went to when he was a brand new DA, after they found out about this conviction integrity unit, it's like, well, what is this? We're prosecutors. We're supposed to convict people, and they laughed at it. And now, Harris County, Austin, Travis County, they all have these.
Adopted it, the CIU.
They do. So that is the reason, why, in my opinion, why we have these exonerations. Mm-hmm. And why the most in Dallas is because we're able to store, because they did store and test the evidence.
I know once Craig Watkins got elected, he said that this was something he was going to do.
Yeah.
He was going to investigate men claiming their innocence and was willing to test the DNA. But it was funny that the old administration wanted him to throw it all away before he even tested anything. Right. And he said that was a red flag for him right there. He didn't want to throw nothing away that could possibly, free somebody from prison for a crime they didn't commit.
Yeah, absolutely.
So another thing I want to ask you, what is the private bar influence on the inconsistencies with judicial discretion?
They get to hold us accountable. The attorneys are the ones that are in the trenches.
Right.
And they know better than anybody else whether a judge is being fair or unfair.
Right.
Whether they're showing up for work or not.
Right.
And when they do show up for work, whether their sentences are being equally applied, because it's a small population. Because they know that, they have that expertise to amplify that. Right. And I say private bar, what I mean by that is the practitioners, like those that are actually in court, the public defenders, the court-appointed lawyers, they know just as well. They're down there every day. The prosecutors that are assigned to different courts that are observing judges making rulings, they know they are, they're the experts because they're there every day.
Right.
The news. They broadcast trials and people get to see, kind of in that one trial, what the judge is like or whatever, but they're not there all the time to really see. And, reputations are earned, and usually there's a reason why.
Right.
There's some issues right now about what is being tested or what judges are allowing to be reviewed in these post-conviction writs.
Right.
And, the private lawyers know.
Right.
Because you're on the inside too. But,
for sure.
It's important. The work that they do is important. The things that they know and they amplify are important. Right.
So what are the socioeconomic factors you consider when sentencing?
Oh, none. I mean, I don't think you can consider a person's socioeconomic status. It's not, to me, right. In making the sentencing determination, which is the hardest part of the job, you have to consider the acts and whether the person appreciated the difference between right and wrong.
Right.
What was the impact on the community? Right. What was the impact on the victim?
Right.
I think that one of the things we've learned from cases like yours and that group of exoneration cases in Dallas County is that socioeconomic status should have no impact whatsoever on the outcome of a case. Right. I don't think that that's always happening.
No, it's not. It's not happening because truth fact is, like, if you don't have money to hire proper counsel,
exactly,
it's just like going in there like blindfolded.
That's exactly right.
Like you playing Russian roulette with your life.
And I think we see that there's been cases that have been overturned because of that. Because the lawyer, wasn't doing what they should have been doing, didn't properly investigate the case, or they weren't given the proper tools by the court. Right. Nothing in life is free. Right. And the playing field should be level. Right. And we know now that based on cases that we've studied in the past, that the most likely way to get at the truth in a case is when both sides are basically equally equipped to go out and do their own investigation.
Right.
Can't rely on one side
Right.
or the other.
Right.
And you have to do that. So what we see is that the quality of lawyers and the oversight by the judiciary on the lawyers
Right.
is better than it used to be.
Right.
There's been more money allocated for agreed upon testing, for the appointment of an investigator, for the appointment of a second chair if necessary in a bigger
Right.
trial, or even
Right.
a third chair.
Right.
So that's a very, very good thing that's happened only in the last 10 or 15 years. And it's only because of the lessons that we've learned from the exonerations like yours.
Right. So I have another question. When it is determined a police officer or detective has used coercive tactics in his investigation or has somehow committed misconduct, how extensively are all of his or her previous cases examined?
I've heard of investigators or detectives, and when I was at the DA's office, there was a few, that when you uncover the wrongdoing, that the investigation goes back as far and as long as they've been a police officer.
Mm-hmm.
It's pervasive. It's the red flag that was raised because of either being caught lying on the stand
Right.
has opened up that investigation.
Right.
That's new.
Right.
Before there was really no, I don't want to say no, but I mean, before it was not as prevalent to go back really far in somebody's record to look
Right.
at what they've been doing. Now there's a do not call or a Brady list where an officer
Right.
has been caught doing something they shouldn't have been doing,
Right.
that they're on this list and they turn it over to the other side. And I think that's becoming more prevalent. The question would be, it's easy now. I say easy. The next step has to be sharing this list on a statewide or national basis. Because you leave one office,
Right.
one PD,
And go to the
next one.
Yeah, same
who
thing
knows?
happens.
Yeah.
You know what I mean? Yeah. What do you think of the current justice climate in 2021 here?
Here in Dallas?
Yes.
I think Dallas is leading the nation for the way that we're handling cases.
Mm-hmm.
You have a very proactive and amenable district attorney
Mm-hmm.
in John Crusoe, who
Right.
is
Right.
who is okay with and encourages review of his cases,
Right.
of the cases in there.
Right.
And that's a good thing.
Mm-hmm.
He's training his prosecutors right. He's taking on issues like bail review hearings.
Right.
He's taking on issues like post-conviction DNA testing in a way that hasn't been done.
What are key aspects that should be adjusted or revamped to improve the current conditions of our criminal justice?
I think the very first thing that jumps out at me is we have to do more with bail reform. The decisions about whether or not somebody is held in custody or not depends on their money. We just talked about how
Right.
unfair that is in a trial.
Right.
It certainly is not a good way to do it for a pretrial. The same people, one of them gets out and one of them doesn't, and the only difference is that one guy's got $500 in his bank account and the other guy doesn't have any.
Right.
And that has nothing to do with their crime or whether they're dangerous or any of that stuff.
Right.
It just is the way that the cash bail system works. So how do you fix it? Well, you've got to have, I believe, the prosecutor and a defense attorney present at the arraignment and the bail setting hearing. I think you've got to be able to give the judge that information, because right now all they really have is the charge and the guy standing in front of them, and that's really all that they have. That's not good.
Right.
Have a little bit of the criminal history, but they need more information. So you got to get more information to them at the beginning. If you're going to use a risk assessment tool, which is, maybe that's, I'm not sure if that's the best idea, but it's an idea. If you're going to use a risk assessment tool, you've got to keep it validated for that particular jurisdiction.
Right.
And then you've got to review those hearings. You've got to review that bond as the life of the case goes on. What appeared one way on the first night is going to be totally different than 30 days later,
Right.
when the DNA comes back or doesn't
Right.
come back, and 60 days later and all that. So you've got to have that system continuous and fluid
Right.
at all times. And that is one of the things that jumps out to me as vitally important. The other one that's vitally important is, something that you've got that you know a lot about, which is post-conviction DNA testing.
Right.
Or post-conviction forensic testing,
Right.
whatever the case is.
Mm-hmm.
It's not as easy as people think that it probably should be,
Right.
in order to get somebody to review the testing in a given case.
Right.
And it should be easier, I
Right.
think.
Okay. So what are your current involvement in the community, specifically underserved communities?
I started a youthful offenders court called the AIM Court. You've been at that. You talked to that one time.
Sure have. Yes, indeed.
And graduated. Man, that's such an amazing thing. We started it in 2016 or 15, really thinking about it and trying to plan and put together. Since then, we've graduated 170 people.
Wow.
170 young men and women who were charged with and indicted for felonies, some of them aggravated felonies.
Right.
But again, looking past the label at the case, what was the case really about? We put them in the program, teach them educational, we give them opportunities, education, driver's license. We get the sort of the logistics of living.
Right.
We give them an opportunity to do that, teach them about budget, address sobriety issues if they need to be addressed, address mental health issues.
Right.
They work through the program and they graduate.
Right.
Felony dismissed.
Right.
That felony is non-disclosed after there. So they untether themselves from the problems of a felony conviction.
Right.
And you and I have seen that.
Right.
Once a person's convicted for a felony, they're convicted for the rest of their life.
Rest of their life.
And I don't know about you, but I mean, I did some stuff at 17 and 18 that I sure am glad I don't have to. I have to live with for the rest of my life.
For sure.
And so, we've graduated 180 people. Now, here's the deal: there's a study coming out in December where they reviewed all the data from that court too. There's some preliminary findings, and the rest of the study will come out in December, like I said. But preliminary findings are that people who graduate from that program, a 75% drop in recidivism. 75% drop in recidivism.
That's huge.
I'm telling you. It's a new way to look at this. Here's the other thing. For every dollar that we spent in AIM court, we saved the taxpayers $8. In opportunity costs, cost of incarceration,
right.
cost of having to go through the trial,
right.
and the people who are graduating are getting better jobs than those that didn't.
Right.
And that's just amazing. And
is.
And I don't know how, that's a hard thing to measure, but I mean, that's a different thing. 25 years ago, these same people would have been tried, probably, if not given time in the penitentiary, a conviction,
right.
maybe deferred.
Right.
But then if you mess up deferred, then that's a conviction, and off you go.
Going to prison.
Yeah. So we've been able to do that. And hopefully that will get replicated and used in other jurisdictions.
How can we bridge the gap of the negative perception or distrust of the criminal justice system and community?
Transparency and accountability.
Right.
Has to be.
Yeah.
As we talk today, there's two very, very important trials going on, not here in Dallas, but in this whole country.
Right.
One of them is the death of Ahmaud Arbery in Georgia.
In the White House.
And then the Rittenhouse in Kenosha, Wisconsin. Right. Juries they're going to deliberate starting tomorrow morning. I was just checking my phone. I've been following that case. If you can see, so when I said transparency, if you want to know what's happening in the criminal justice system, we can now see it for our own eyes.
Right.
Kenosha, Wisconsin. The video speaks for itself. The arguments of the lawyers are there for everybody to see.
Right.
The behavior of the judge for everybody to see.
Right.
In Georgia, when Roddy Bryan's lawyer got up and said, "I don't want to have any more black pastors,"
right,
in the gallery,
right,
like I couldn't believe that
he said that.
He couldn't believe he said that.
I couldn't either. Like, what did that have to do with your trial?
Well, nothing.
Exactly.
And I mean,
exactly.
So the way I say about that, though, is accountability, transparency and accountability. Now, the judge in that case had an opportunity, if he wanted to go with them on that,
right.
but he didn't.
Right.
But now we know about that lawyer,
right.
And we know that sometimes they try to make the case about something that it's not.
That it's not.
And, the same thing up there. So and my charge is this, once you have transparency and once you know what's actually happening, from then you can be accountable. You can hold somebody accountable. Right. How do you do that? Jury service, voting.
Right.
That's the only way to do it, at least here in Texas.
Right.
If you don't like the way, I mean, if I ever stood up and said, no more white pastors, no more black pastors, or whatever, then y'all should vote me out.
Exactly.
And do it quick.
Exactly.
The same way with the way that you conduct the trial. Right. There's been a lot of chatter about whether or not the judge up in Kenosha is got his thumb on the scale.
Yeah.
And you can see for yourself whether he does or does not. And if he does not, then your opportunity is to hold him accountable at the ballot box.
At the ballot box. Because he's been unopposed for many terms.
Yeah.
And when I saw him take his phone out because it had started ringing the Donald Trump campaign song, that kind of took me aback.
Oh yeah.
And then when you're sitting up here reading a magazine about cookies, is that judge not taking his job seriously, or he already feel like, I know what the decision of this trial going to be, so it's no need for me to look professional?
Well, I won't get in his head. What I can say is that one of the most important things that you can do as a judge is to make sure that you create an environment and that your rulings are crafted so that the truth comes out, and you're not a distraction, and you don't let any distractions go on. You've got to create a neutral, sterile environment where both sides have an opportunity to ask questions, where the judge doesn't send any signals,
right?
Where the law is the law. And let me just say this: not every decision is going to be popular,
right?
And listen, as the judge, you can't be guided by what you think is going to be popular, because that ain't right. You have to be guided what you think the law is. And you've got to take yourself out of it. And so the point of it is that, when you're presiding over a trial like that, you don't want the discussion to ever be, what was the judge doing? Right. You want the discussion to be about the facts of the case. Right. This dude should have been convicted or should not have been. He wasn't self-defense, he wasn't. He provoked it, he didn't. Right. Whatever. But the judge is out of it. And unfortunately, it doesn't seem to be happening up there.
Right. Find a question to you.
Okay.
It's kind of for you anyway. What is your driving force that keeps you engaged in your career? Why did you enter the field versus what's keeping you here?
Now, why did I enter the field? Well, I entered the field. First of all, I never knew a lawyer growing up. I just never did. Right. My dad, towards the end of his career, saw that his business was buying other companies, okay? And he saw these lawyers and they were negotiating these deals, and he realized how much money they were making. So he comes home and he's like, "You're going to law school, okay?" He's like, "You're going to law school." I said, "Okay." And so when I got there, I wanted to be a trial lawyer. I always wanted to be a trial lawyer. None of the other listen, property law, no offense to the property lawyers and judges and all, but wills, trusts, and estates, it just didn't grab my attention.
Right.
Criminal law is fascinating to me.
Right.
It always has been.
Right.
It's the fight between good and evil.
Right.
It really is. It's the most important decisions that we make, because you're talking about a person's liberty. Right. Money comes and goes, but liberty is forever. Forever. And so it's that. So I decided I want to be a trial lawyer and I want to study criminal law, and I did that. I got hired on at the DA's office, and that passion kept growing. Became a judge because, I saw that I could really help people, and I could provide a better environment for the truth to come out, I thought, than some of the other judges that I saw. Right. And man, I can't believe that I get to put on the robe every day. It really, it's a trip, man. It really is. I put it on in a little bathroom before I go out there. I'm like, it's hard to believe. Right. It's very hard to believe.
Well, once again, Judge Brandon Birmingham, we want to thank you for allowing us to have some of your time and gave us some great points. And you always give us what we need instead of what we want. So much success on your upcoming election. Glad you're unopposed. Yeah. It was a pleasure.
Yes, sir. It's always good to see you, Chris.
Appreciate it.
Appreciate you.